Can I have parties announced for the record? State.
Antonio Arriola.
Defense.
Written hour for Mr. Wilson.
And are you Mr. Wilson?
Yes, ma'am.
And cause number ending in 27B. You're charged with deadly conduct, discharging a firearm in count 1 and count 2. Is that correct, state and defense?
That's correct, Judge.
Yes, Judge.
All right. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 28B. You're charged with the offense of aggravated assault with a deadly weapon. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to your plea bargain agreement, the cases are to run concurrently. The state is taking in consideration 2024 CR 3009, County Court Cause number 732604. And in the plea bargain agreement ending in 27B, state is proceeding on counts 1 and 2. Punishments be assessed at a cap of 10 years in the prison. There's a $2,000 fine. There is affirmative finding of deadly weapon, and the state is opposed to your application for deferred adjudication. There's to be restitution, if any, to the complainants. And then in the cause number ending in 28B, there's a cap of 12 in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application. There's to be restitution, if any, to the complainant. Did you understand that to be the plea bargain agreement in each cause number?
Yes, ma'am.
Then in cause number ending in 27B, how do you plead to count 1? Guilty, not guilty, or no contest?
Okay, no contest.
Count 2, how do you plea?
No contest.
And in the cause number ending in 28B, how do you plea?
No contest. No contest.
State any evidence.
For each case, the state offers State's Exhibit 1 with attachments.
We've reviewed them and have no objection.
In each cause number, the court will find there.
Here's where things get real. Wilson pleads no contest. That's basically saying, I'm not admitting guilt, but I won't fight the charges. Why might a defendant choose this route? Drop your thoughts in the comments.
There's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. We're going to come back on December 19th. I'm going to ask for a PSI TAP evaluation. On the 19th, I'll review whatever evidence is presented to me and make a decision on your application.
Yes.
All right. Is there anything else from either side?
No, Your Honor.
Nothing from the defense.
Curtis Ray Wilson. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense.
Written hour for the defense.
And are you Curtis Wilson?
Yes, ma'am.
All right. You entered a plea on November 7th to aggravated assault with a deadly weapon. According to the plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application for deferred adjudication. This will run concurrent with 2024 CR 2927B, and the state is taking into consideration some cases. All right, and also 2024 CR 2927B, and that cause number, you enter pleas to count 1 and count 2. The state waived count 3, and that's a deadly conduct discharge of firearm. And according to that plea bargain agreement, punishment is to be assessed at a cap of 10 years, and it's to run concurrent with 2024 CR 2928B. And there are 2 other cases that are being taken in consideration. Any witnesses, state?
No, Your Honor.
Defense, any witnesses?
Judge, we have none to testify. I provided the court a motion I filed this morning with statements from members of the family. We do have 3 members of the mother, father, and stepfather are present in court in support. They're not asking to testify.
All right, any objection to the court reviewing the letters of support?
No, Your Honor.
All right, just give me a moment. Let me review that. And the letters of
support from family and teachers. This is a big deal. Judges often weigh these heavily, especially for young defendants. But do you think positive letters should outweigh serious charges like this? Let's hear your opinion.
Support are from the defendant's father, former teacher, cousin, stepfather, and mother.
That's correct.
All right, the court has reviewed the letters. All right, defense.
Obviously, we're asking for the deferred adjudication, Judge. We'll get here in both cases by law of parties and not by direct action by him. Mr. Wilson was 19 years old. In fact, he turned 22 months ago at the time of this offense. He has graduated from high school, actually withdrew from Sam Houston, finished it online, home tutored by his mother. He had just gotten with the wrong people, going places, not questioning where he was going. He and I have talked a great deal since he's been incarcerated. He understands that you can't just pick up with people and go and not ask what's going on. He has some positive plans as indicated by the letters for his future. The young man has a good head on his shoulders and a good positive attitude and definite plans for the future. Sending him to prison at this point in his life is certainly not going to do anything for him or society. Giving him a chance on deferred, understanding the full weight of the punishment is pending over his head should he not make it. He's motivated to finish that, get out there, get training, and just become a productive member of society. He intends eventually to own his own business, looking at truck driving and some other things. So he's looking at the future. He's had a lot of contemplation since he's been in custody. He certainly does not apologize, is not the right word. He's almost ashamed that he was involved in this thing at the scene. He was a passenger in a vehicle. He knows he shouldn't have been there. We're asking for the court to give him a chance.
State, the defense is saying that he did not know what was going on or what was going to happen. Do you have any response for that?
This. Everybody makes mistakes. You make a mistake, don't do it again. I got caught up with something because I was with other people. Well, Mr. Wilson doesn't actually acknowledge what mistake it is that he has made. And as far as I can tell, abdicates responsibility for the choices that he made. He got caught up with something because he was with other people. Not he chose to be with those people. He chose to do what they did. He got caught up. As far as I can tell, Mr. Wilson still...
The judge isn't buying the wrong crowd excuse. Notice how she drills into personal responsibility. Classic courtroom moment. Viewers, do you think the judge is being too harsh or just holding him accountable?
refuses to take responsibility for his choices. And as long as he's going to refuse to take responsibility, he belongs in prison.
All right, so I'm reviewing the facts of the case, and in the facts of the case, it says that the person identified him because they knew him from school. He identified which position he was in, and that a person went in with a mask on. So at what point are you not aware of what people are doing? That's what I'm trying to figure out.
The question was about what was going to happen, what was happening at the time when everything is happening. Well, he was with the people. They were going to do something. He went along with them. His mistake was not understanding what was going on, not asking questions about what's going to happen.
So he's saying that
When people, actually there were multiple cars involved in this case. The one that he was in didn't have anybody in a mask. That came out of a different car. He never left the vehicle. He didn't have the firearm.
All right, if he's saying he didn't know about,
Arguing about whether or not the other people had firearms or not in that vehicle.
all right, if he's saying he didn't know about this plan and he wants a jury trial, I'll give him a jury trial. But based upon what I'm reading in the reports, I don't think he's a good candidate for probation.
Let me talk to my client.
Sure. All right. So what is it? Just one second. We're back on the record in 2024 CR 2927B and 2024 CR 2928B. Defense, did you have a chance to confer with your client?
I have, Your Honor, and given the choices we have, we'd ask that we'd like to withdraw the plea and get trial setting.
All right, Ms. Ferguson, can I have a jury trial setting on Wilson?
1 second.
State, how long do you expect this trial to last?
4 days.
All right.
You can do March 4th.
On Curtis Wilson? All right, where's Mr. Wilson?
State tells me he has left the building.
All right, so I'm going to issue a warrant for his arrest.
Judge, I'm asking that he be remanded without bond.
I'm going to issue a judge's warrant and remand him without bond. And we're going to go on the record. Court is calling 2024 CR 2927B, 2024 CR 2928B, 2024 CR 3099, State versus Curtis Wilson. Can I have parties announced?
Megan Galloway for the state.
I've written out for Mr. Wilson.
All right, this hearing is scheduled at 9 a.m. I did notate that I saw Mr. Wilson.
And here's the bombshell. Wilson doesn't show up, and the judge issues a warrant without bond. This is serious. Skipping court often destroys any chance of leniency. Have you ever seen a judge flip this quickly?
In the courtroom. Did he show up for court today, counsel?
He did, Judge.
All right. And Deputy, could you make an announcement for Curtis Wilson in the hallway, please?
Okay.
All right, thank you. All right, defense, do you know where your client is?
Do not, Your Honor.
All right, state.
Your Honor, I'm asking that the court issue a judge's warrant and remand the defendant without bond.
All right, the court will issue a judge's warrant in each cause number and remand your client without bond. And the court did today receive a violation report. Counsel, have you had a chance to review that?
Given to us about an hour ago, Judge.
All right. All right, thank you.
Thank you, Judge.
Sure. Court is calling 2024 CR 2930 and 2024 CR 2928A. Can I have parties announced for the record for the state?
Jason Garrett.
Defense?
Melissa Christian.
And are you Mr. Yanes?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client? And the cause number ending in 2928, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 2930, you're charged with aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each case, punishment is to be assessed at 16 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The causes will run concurrently with each other and also concurrently with 723230. The state will take in consideration 2024 CR 2930. And in the cause number ending in 2928A, you agree and judicially confess that you committed these acts with Curtis Wilson. Did you understand that to be your plea?
Yes,
And
ma'am.
the cause number ending in 2930, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause number ending in 2928A, how do you plead? Guilty, not guilty, or no contest?
No
Are you
contest.
proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Judge, we've thoroughly gone over the paperwork, and Mr. Yanes clearly understands his position in all of these cases, and we would just ask that the court follow the plea bargain.
All right. Then in the cause number ending in 2928A, the court will find you guilty, sentence you to 16 years in the prison. This is run concurrent with 2024 CR 2930, County Court cause number 723230. Taking in consideration 2024 CR 2927A. And in that cause number, the court is finding, based upon your plea bargain agreement, that you acted in concert with Curtis Wilson, and there's an affirmative finding of deadly weapon. The court will give you credit for any time served. Anything else with regards to sentencing under that cause number?
No, ma'am.
And cause number ending in 2930, the court will find you guilty, sentence you to 16 years in the prison. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 2928, 723230, taking in consideration 2024 CR 2927A, and give you credit for any time served. Is there anything else with regards to sentencing in that cause number?
No, ma'am.
We can go off the record. How old are you?
20.
All right, you're 20. I know that's a lot of time. Any time that people do in custody, even if it's a day, it's a lot of time. But you still have a chance to improve your life. When you go to the prison, I understand that sometimes people will join organizations for their safety, but do not go to prison and become institutionalized. You have a chance, if you don't have your high school diploma, you have a chance to get your GED. You have a chance to get a college degree. You have a chance to get a trade, so when you come back out, you can change your life. You understand? And when you're released, if being in San Antonio is not helpful for you because of the people you surround yourself with, then leave.
The timeline of violence gets tangled. Murders, shootouts, stolen guns, and SWAT raids. This isn't just a bad night. It's a pattern. Could early intervention have prevented this? Comment your thoughts. This one's intense.